Pursuant to notice, I call up H.R. 7015, the Protecting Third-Party Litigation Funding Form from Abuse Act for purpose of markup, and move the committee report favorably to the House. The clerk will report the bill.
H.R. 701.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from California, Mr. Issa, for an opening statement.
Mr. Chairman, I will have an amendment. However, as an introduction to the bill, we've made virtually all the amendments that were possible in from the previous version of the bill. We've reached out to every group on the left and the right and satisfied everyone we could satisfy. It is clear you cannot satisfy everyone because of a problem that exists within the court system. In some courts, Mr. Chairman, a judge will routinely ask for the source and information for third-party funders of litigation, because clearly the third-party funder has at least some likely influence on whether or not the product can be settled, and in most cases, particularly cases that involve intellectual property, they absolutely need to be known if you're going to write a protective order that covers whether or not they should be excluded. Having said that, currently it's inconsistent. In Delaware, where one judge began doing it routinely, he simply doesn't get the cases anymore. In others, where they do it periodically, they will probably be avoided. Those who never ask are the favorites of trolling organizations and plaintiff lawyers who are using third-party funding that for some reason they are unwilling to divulge their source. Having said that, there were legitimate concerns brought up in this legislation early, and we have addressed those. The first and foremost, the amendment, not mine, but that was offered that made the most sense was that in all cases, the judge will start with an in-camera review, thus determining whether or not the defendant has a reasonable need to know it, but at the same time letting the judge know whether or not there's a need for this to affect protective order and other activities. You might ask, what is the problem with this bill then, if we've met at all? The problem is there's dark money. And when I say dark money, I mean sources that people are ashamed to say where they're getting it from. We have put in protections so that people who simply contribute money to a cause are not discoverable. We've put in additionally that you are not discoverable if in fact you do not share in the profits, meaning that if an organization or group simply backs the cost of the bill, including the return of their original investment, they still are exempt from this. The only way to actually be discoverable and potentially that information turned over to the defendant is if in fact you are effectively the plaintiff, meaning you share in the profits and likely share in the ability to settle or not settle. That means that when there's a request for a mediation conference, there's an expectation that the person coming has the right to make a settlement and not in fact simply to arrive and go back to an unknown source for those settlements. Today we will undoubtedly hear a number of amendments coming from a number of people. I've been informed that those amendments seek to gut the bill, and I will be opposing likely all of them. None of them have been presented in advance, which is not in the spirit of finding a solution. I will address in closing one item that has been brought to my attention. I was a small inventor for more than 20 years. I have 37 patents. I know full well how expensive it is to take on the big guys, including Chrysler Corporation and others. Having said that, third-party funding can be essential to do a $3, $4, $5 million case, even if, in fact, you expect to be successful. It may not be something you can bet the farm on if you don't already own the farm. For that reason, we have made every effort to make sure that there is nothing that would diminish or reduce the ability to get third-party funding unless that third-party funding comes from George Soros, who in an un-American way wants to stop something, or the Chinese communists who want to slow our technology, or, for example, Huawei, that repeatedly seeks to have trolls who will, in fact, try to stop 5G and other developing technologies by endless litigation, slowing down, or in some cases, even stopping development. All of this is the reason this bill is before us today. Mr. Chairman, I look forward to proceeding forward. I yield back.
Gentleman yields back. With the chair now recognizes the gentlelady from Vermont for an opening statement.
Thank you, Mr. Chairman. Third-party litigation funding, or TPLF, is exactly what it sounds like. Third parties invest in litigation in return for a share of the contingency fee or the damages awarded should the party they've invested in win. It represents a practical solution to the problem that many Americans face when they need to go to court to obtain justice. Litigation is often prohibitively expensive, and third-party litigation funding helps ensure that no person is denied their day in court because of financial barriers. Third-party litigation funding levels the playing field for ordinary Americans who face powerful corporations, which is exactly why major business interests are now working to discredit it. These corporate interests want you to believe that TLPF agreements are nefarious. They suggest that third-party funding is somehow giving ordinary people an unfair advantage against these large and powerful corporations. They have proposed this bill that they say brings transparency to the system. Less than 2 months ago, we were scheduled to consider a bill just like this very proposal, one that promised to bring again, quote, transparency to litigation. But groups representing the people and organizations who rely on TPLF, Republicans and Democrats alike, told us how the bill might end this form of litigation altogether. And the bill was pulled from markup. For a moment, it appeared that this bad idea was finally behind us, yet today we're presented with largely the same text under a different name. Some of our colleagues across the aisle say this is a negotiated text. Well, I know the ranking member certainly was not asked for his opinion, and if he'd been asked, he would have said that the minuscule change that they're touting as a grand compromise was already necessary to comply with the Constitution. That's right, in 1960, the Supreme Court unanimously agreed in Bates v. Little Rock that requiring the NAACP to disclose its contributors unjustly interfered with the members' freedom of association, which is protected by the Due Process Clause of the 14th Amendment from invasion by the states. So this new text suggests that member and donor lists of TPLF funders don't have to be disclosed in some situations, is simply a restatement of governing law. In any agreement where the members and donors have a financial interest in the outcome, which happens frequently with TPLF, would still require full disclosure under this bill. All of the risk is still there, and for all practical purposes, this bill remains unchanged. Whether we call it protecting TPLF or encouraging transparency, Americans can see the truth. All today's bill does is advance powerful corporations' ability to escape responsibility for the harm that they cause communities. The fact is that this bill is not about fairness. Opponents of third-party litigation funding haven't suddenly seen the light and want to protect TPLF. And this bill is certainly not about transparency. If it were, my colleagues would at least acknowledge that both state and federal judges already have the power to demand this information from litigants. If more transparency is necessary in any of these cases, courts are free to demand it. Instead, these bills are about stacking the deck in favor of big business so corporations that break the law can drag out cases and dodge accountability. By forcing plaintiffs to reveal their backers, these bills will let the deep-pocketed defendants stall, intimidate, and drive up costs until the plaintiff is forced to give up. And increasing the disclosures needed to file a claim in court makes third-party funding more cumbersome and expensive. And it is an attack on the litigation victories that third-party litigation funding has enabled. For example, the famous 1993 lawsuit brought by Aaron Brockovich against Pacific Gas and Electric Company for dumping a carcinogen into the water supply of Hinckley, California, which was partially funded by an outside provider. The women in small law firms who sued Pfizer to prove their drug caused a breast cancer epidemic could not have done so without TPLF. Victims of the opioid crisis were able to sue the Sacklers to bring justice to the over 650,000 individuals who died during the epidemic thanks to TPLF. These are just a few examples of people who never could have gotten their day in court without outside funding. Everyday Americans cannot afford basic health insurance or groceries or housing, yet my colleagues across the aisle suggest that if they're harmed by a major manufacturer or corporation, they should just pay for it themselves. The bill stacks the deck in favor of corporate interests and against the people, and I intend to vote no. And I also want to bring up the point that opposition to the abusive transparency measures in this bill is actually, in fact, bipartisan. When some Senate Republicans tried to all but end TPLF in the big ugly bill earlier this year, other Republicans stood on principle to say that ending it was wrong. And this past June, Laura Loomer posted on X, quote, litigation finance is a critical weapon for the little guy, empowering consumers, whistleblowers, and small inventors to take on corporate titans. And last week, Gene Hamilton of American First Legal wrote that he is continuing to oppose the bill. He wrote this on X. Now, American First Legal and I don't agree on much, but we have common ground in the opinion that, as he wrote, quote, the bill only serves the interests of the Chamber of Commerce and not the American people. So again, I plan to vote no. I urge my colleagues to vote with me, and I yield back.
Gentleman yields back without objection. All other opening statements will be included in the record. The chair now recognizes the gentleman from California to offer an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment to the deck.
Clerk will report the amendment.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair now recognizes the gentleman from California to explain the amendment.
Chairman, the amendment is not substantive in nature, but simply as a substitute changes the year and title of the bill. It does not change the substance of the base bill. Yield back.
Gentleman yields back. Gentleman from Wisconsin, Mr. Fitzgerald is recognized.
Thank you, Mr. Chairman. I'm proud to support my colleague, Mr. Issa's bill, the Protecting Third-Party Litigation Funding from Abuse Act, and urge its passage. Third-party litigation funding, or TPLF, has grown quietly but explosively over the last decade. According to a 2022 GAO report, TPLF was estimated to be a $12 billion industry in 2021, although some sources now put it upwards of $18 billion today. Litigation finance offers a high-risk, high-reward strategy. And some in front of this committee have even equated it to basically gambling. Now there is nothing inherently wrong with financing a lawsuit. I share my colleague's sympathy for the small business or for the single investor who's forced to defend themselves against Fortune 500 corporation with deep pockets. In those instances, TPLF helps create a level playing field, and this legislation would not stop that. But when the financing is undisclosed, when it shifts control of litigation from a plaintiff to a silent investor, and when it potentially places decisions about U.S. lawsuits in the hands of foreign entities, including those with ties to geopolitical rivals, Congress has responsibility to act on this. This is precisely what H.R. 7015 does. It simply requires transparency. It requires parties to disclose to the judge who's doing the financing on the lawsuit and what rights those funders have acquired. The reason transparency is essential is because TPLF can undermine the most basic expectation of our legal system, that clients are in control of their own cases. This is not a hypothetical scenario. It is an established pattern. The most famous example was in 2023 when Cisco, the U.S. food distributor, wanted to settle a price-fixing lawsuit, but its TPLF funder, Burford Capital, countersued Cisco because under the terms of the TPLF agreement, Burford had final say in any settlement discussions. In other words, Cisco wanted to settle, but Burford wanted a higher return on investment. In several instances, funding contracts have given investors veto power over strategic decisions such as which lawyer to hire, whether and when to settle, whether to appeal, or whether to pursue certain claims. And because these arrangements are usually secret, courts are left unable to access conflicts of interest or other ethical issues that arise from these arrangements. Transparency is not only important for protecting a client's interest, but also critical for protecting national security. We know that foreign adversaries are increasingly sophisticated in using economic and legal tools to influence U.S. institutions. TPLF offers a direct avenue for foreign actors to inject capital into U.S. litigation and potentially shape legal outcomes affecting strategic industries, intellectual property, or sensitive technologies. Consider a scenario where a foreign-owned investment firm funds mass litigation targeting an American defense manufacturer. By steering litigation strategy from prolonging discovery to punishing for disclosure of proprietary information, a foreign actor could gain access to data, to sensitive data, or weaken a critical supply chain partner. And because TPLF agreements are currently hidden, neither the court, nor the government, nor the American public would know who was ultimately pulling the strings. Or consider complex intellectual property litigation. A fund with ties to a foreign competitor could bankroll lawsuits intended to drain resources, pressure firms into an unfavorable settlement or licensing agreement, or force disclosure of trade secrets. And better yet, they could slow or altogether stop the rollout of key technology through an injunction. These are not speculative concerns. We have already witnessed foreign sovereign wealth funds invest in U.S. patent lawsuits for the purposes of gaining access to U.S. intellectual property. Disclosure will ensure that the courts knows who's involved and can take appropriate steps in response during litigation. It ensures that when strategic decisions are made in American courtrooms, they are not secretly influenced by entities whose interests may be adverse to their own. Some will argue that disclosure imposes a burden, but transparency is not a burden, it's a safeguard. The only parties disadvantaged by disclosure are those who benefit from secrecy. Our courts routinely require disclosure of financial interests, insurance, ownership structures, and conflicts. Extending that practice to litigation funders is simple fairness. In passing H.R. 7015, we reaffirm a basic principle, that our civil justice system should be predictable, neutral, and accessible. I urge my colleagues to support this common sense bill. Our courts, our litigants, and our national security deserve nothing less. Thank you, and I yield back.
Gentleman yields back. Gentlelady from Washington is recognized.
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
When a bill similar to this one was scheduled for markup a few months ago, my colleagues on the other side and I had a very robust back and forth about the consequences of disclosing third-party litigation funding. And I expressed my concern then that disclosure would give large corporate defendants a unique and undue advantage in a legal system that's already rigged against ordinary workers, consumers, victims, survivors, and small businesses. It would do this by arming corporate defendants with knowledge about how much money the victim has to prove and sustain their case, and it would allow the corporation to bury the victim in costs and draw out the case until it becomes financially impossible for the victim to continue pursuing the case. Now, these weren't just Democratic concerns. Conservative groups like America First Legal, co-founded by Stephen Miller, the Oversight Project, a spinoff of the Heritage Foundation, also strongly opposed the legislation because disclosure would discourage funders from investing in litigation for fear of negative exposure or harassment, likely in violation of their First Amendment freedom of association. So when I learned that the bill text had changed, I was hopeful that maybe these changes were going to address some of those concerns. But sadly, the changes have only further tilted the scales of justice in favor of corporations by, for example, making the disclosed information admissible in court and requiring the disclosure much earlier in the litigation. And while the bill now prohibits the disclosure of donor lists, that prohibition exempts all donors who provide third-party litigation funding, an exception that essentially swallows the rule. So it shouldn't be surprising that there are conservative groups as well as liberal groups that still oppose this bill. Access to justice is the backbone of any democratic society, and in today's economy, there are just too many people who are priced out of the very system that exists to protect them. Working class Americans with very few resources are being harmed by massive giant corporations that are responsible for all kinds of wrongdoing. These include mothers suing a pharmaceutical company for its cancerous baby powder, families of victims of school shootings suing a gun manufacturer for marketing AR-15s to teenagers, small inventors suing large companies for stealing their creations, and female employees suing an insurance company for discriminating against them through lower pay and fewer promotions. These vulnerable Americans are facing massive corporations. They're armed with a lot of money, plenty of money, and they're not afraid to use it as a bludgeon to make sure that any challenge to their agenda is bludgeoned down before it even gets started. Litigation is incredibly expensive, and that cost barrier alone can determine who wins and who never gets heard. Third-party litigation funding gives working-class Americans a fighting chance at holding corporations accountable. This bill is not just harmful, it's also unnecessary in the sense that under current law, judges already have the power to review litigation, financing agreements, and ensure that those agreements are fair and ethical and compliant with the law. Judges are already trusted to supervise the relationship between attorneys, clients, and third parties when it comes to attorney fees and class actions and bankruptcy settlements. And there's no reason that they can't continue to be trusted to oversee litigation financing agreements. With this bill, you would block ordinary consumers, workers, mom and pop shops from holding big corporations accountable for causing cancer, for contributing to mass shootings, for stealing inventions, for discriminating against their workers. And so I hope that my colleagues on both sides will vote no, reflecting the opinion that's coming from both conservative groups and liberal groups in this particular situation. I urge my colleagues to vote no, and I yield back.
Gentlelady yields back.
Move to strike the last word.
Gentleman from Kentucky is recognized.
You know, a lot of the fights or the debates up here are left versus right, and there are a few of them that aren't left versus right. This is one of those. This is the big guys versus the little guys, and we don't have enough people up here speaking for the little guys, which could include patent holders who've taken a beating legislatively in the courts over the last decade or 2 decades and are struggling. This is just another effort to keep them from getting their day in court. There's a boogeyman here, which is China or other foreign adversaries. If that were really what this bill was going to go after, we could narrowly tailor a bill that did that. And in fact, I'll offer an amendment to make this bill into that. But that is not what this bill is. This bill is so overly broad that it will basically deter investments in legitimate claims that startups and small plaintiffs have. The bill's language is so expansive that it may require disclosure of entire chains of financial interests, including venture capitalists, limited partners, pension funds, or even shareholders of public companies. It compels submission of funding agreements to opposing parties without protections for proprietary information like funding amounts, waterfall structures, or investment terms, information that has no relevance to the legal merits of the case. But it could help the defendants, the big guys, know how deep your pockets are and how long they're going to have to go to starve you out in the litigation. Even the requirement for in-camera review is problematic. Defendants are not required to disclose indemnification agreements, yet plaintiffs must expose sensitive financial backing that could be weaponized through retaliation, harassment, or reputational damage. Registered investment advisors, already subject to full FEC oversight, would be swept into disclosure mandates, duplicating regulations without any national security justification. And by admitting that these disclosures are inadmissible and not discoverable, the bill concedes that they serve no evidentiary purpose and are instead designed to chill litigation finance, ultimately benefiting large corporate defendants. You don't have to take my word for it. Listen to the groups on the outside, some conservative, some liberal, but all trying to represent everyday Americans who deserve their day in court. And if this bill passes, it will squelch their voice by cutting off their funding, by intimidating their financiers. And that's what the big guys would love. So I'm going to be opposed to this bill, and I will offer amendments, and hopefully they will be accepted because they're offered in good faith to do what we're being told the bill does, which is to keep foreign adversaries from infiltrating our courts and changing the balance of justice in the United States. And with that, I yield back.
Gentleman yields back. Gentleman from North Carolina is recognized.
Thank you very much, Mr. Chairman, and I couldn't agree more with Mr. Massey. In particular, this is going to hurt small patent holders who do not have the ability to finance their inventions, do not have the ability when big corporations come in and try to steal their inventions. It is going to, the definition that we have, by saying any person entitled to any payment or thing of value in the act is overbroad. It's going to threaten limited partnerships, equity investors, family offices, a wide variety of things. And I agree, if we have a concern about foreign investment, then we can have a very narrow rule that talks about when it's a foreign investment or a foreign investment that is not an investor in the underlying invention or patent. But the other thing that I want to say about this David versus Goliath situation is that we're seeing even more roadblocks put in the way of people who want to file litigation against large players. We're seeing limits in how people do class actions. We're seeing limits in how you can get an injunction and whether it just applies to you or can apply to somebody else. All of these things make it harder and harder for people who don't have means to protect their intellectual property, protect their rights, protect their safety, protect their families. And so when we do things that make it harder for people to get access to the courts, it must be extremely narrowly tailored, and there must be a compelling interest for doing it. What I'm seeing right now is that the compelling interest is the profits of people who might be in litigation. And that is not sufficient for me. I will be voting no, and I'm glad that people on both sides of the aisle are seeing it the same way, and I yield back.
Gentleman yields back. Gentleman from Texas is recognized.
Thank the chairman, and I would like to associate myself with the remarks of the gentleman from Kentucky. I will also not be supporting the legislation as drafted. Look, you know, there are kind of three ways things go in this world. You get ground out by the market, a market which, you know, I generally support existing, but people can get ground out by government and the market and so forth, but you gotta have recourse. You either have some regulatory constraint, which I'm not overly fond of, or you have litigation where you can go exercise your rights to go push back when that system creates issues. And the trial bar has often done things that create a bad reputation, but as have corporations and as have government and as have bad regulations. In this environment here, I feel that this is, and I'll align myself with what my friend from Kentucky said, you know, lining up with the big guy versus the little guy as a general proposition. I think this is more doing the kind of Chamber of Commerce bidding than it is in trying to create a structure that I think works the way it should. And so from, you know, my standpoint, I am interested in what my friend from Kentucky might put forward to limit it, to target it. I understand the merits behind wanting to do something here. I get it. And I certainly believe it was done in a good spirit by my colleague who introduced the legislation. But I think this is going to create an environment where we're going to stifle the ability of people to be able to help finance and fund people who need to stand up and be able to push back on the wheels that will grind out the little guy who has no recourse. And I just think we've been going down the big guy road for far too long. And by that, I mean big government and big corporation, and frankly, where those roads intersect is the worst intersection. So I'll be happy to look at my friend from Kentucky's amendments, but as it stands, I'll be opposing the legislation.
Gentleman yields back. I believe the gentlelady from California, and I think the gentleman from Kentucky has an amendment. Gentlelady from California is recognized.
Thank you, Mr. Chair. I too will be opposing this piece of legislation. You know, and I would like to associate myself with some of the remarks that I just heard. You know, as has been stated, the little guy, the working person, is getting hemmed up, taken advantage of, screwed by big corporations on a daily basis. That's what folks say. And sometimes the only recourse is to take somebody to court. It's how you get somebody's attention that has a lot of money. And sometimes, oftentimes, it's the only way to get them to do the right thing. And this piece of legislation would essentially take that recourse away from them. Disclosure to a judge is already part of the law. But forced disclosure to a corporate defendant is really about sharing and exposing your strategy, which only hurts the little guy, who oftentimes is trying to find a lawyer that they can afford who will ride with them to try to get them the justice that they need. I think it's a shame that it is so expensive to sue. But that's where we are. I also think it's a shame that we're trying to take away as many opportunities as possible for the folks who are getting up every single day trying to do the right thing, who get hurt, to take away tools that they have to hold these big corporations accountable. Because we know that the big boys have a massive legal team, they have endless amounts of money, and they have time. They have time that the average American does not have. And they can have discovery up the wazoo, which costs money. They can run down the clock, which costs money. They can have all these filing fees, which add up and cost money. And then the small attorney who's doing right by their friend and representing them in court against a big corporation, they're like, well, you only have 2 weeks or 2 months to fight against the person who, the company that maybe killed somebody, that maimed you on a work site, that maybe helped contribute to you getting cancer. We only have enough money to fight them for 2 months, and then you might have to settle and get pennies and get nothing, and this corporation can continue to do the bad things that they've been doing. So I don't know why anyone would say, let me continue to hem up the average American who's struggling hard, who gets screwed by the big corporation. Let me just hem them up even more. We spent the better part of the morning fighting for those folks, and now I guess in the afternoon we put on a different hat and we all stop fighting for them. I don't understand that. And this isn't about foreign entities and like secrets. Because if that was the case, we would have had a whole bunch of hearings about this administration selling our chips, our national security secrets, to China for a 25% commission fee. So let's just call it what it is. Somebody has decided to jump in bed with the big corporations and the folks interested in monopolies who want to wear down working people and screw them even more, and they came up with this legislation. And I think we have an obligation to stand up and say, this isn't passing the smell test. Because ultimately, this kind of legislation is how you delay justice, it's how you deny justice. And I can't stand for that, which is why I will be opposing this bill. I'm curious about the amendment that will be brought forth from the gentleman from Kentucky, but as it stands now, I'm opposing this piece of legislation. Thank you, and I yield back.
Thank the gentlelady. Yields back. I, too, am interested in seeing amendments that have been withheld. At this time, I'll ask unanimous consent and I'll summarize 6 groups in support of this legislation, including groups like the National Insurance Crime Bureau, all of which, by the way, their contributions or their ability to defend someone is discoverable already and routinely, of course, is discovered. Additionally, I'd like to place on the record a Bloomberg article entitled "Soros Backs Personal Injury Lawsuits in Market with 20% plus Returns." And with that, without objection, so ordered, and I'll strike the last word myself at this point, if you don't mind, Mr. Ranking Member. I think it's important that we make the record complete. Many of the statements so far have said, little guy, little guy, little guy. What's amazing is that it's in fact the big guy that's funding this against little guys. What often happens, and almost every case that I've looked at, including one that we'll have a hearing on tomorrow, third-party funders are going after systematically owner-founded small companies and extorting from them using their unlimited power. They have little, and when they run out of insurance, they have nothing, and they settle. They'll run up a $600,000 bill before you know it, and they're out of money. So let's understand, under the current rules, without a change under this legislation, what really happens is plaintiff files a suit. The first thing he wants to know is how deep are your pockets? What is the insurance? He gets that information. He finds out from the defendant how deep their pockets are, what the settlement is, and then if there's going to be a settlement offered, it is in fact based on what they can willing to pay. But more importantly, they know how much they have to make them spend to run out of money and then ultimately have to make a hard decision to settle. Little companies are routinely rolled up one after another by these groups. All we're trying to do is balance it. Additionally, the acting ranking member at the time described in straight terms Cmte, a procedure that is not something that is in fact not allowed. And yet she described what this is as, profit sharing by a third party. These contracts are carefully written in most cases to avoid that accusation so they can claim, well, we're really not the co-investors in litigation, but they are. The fact is, all we're asking for is decisions to be done with specific safeguards greater than exist in the law today to protect the innocent donor and so on. One of the pieces of amendment that I'm sure will be offered is one that says, well, we're going to exempt it if it's an American citizen. Well, of course, an American citizen or American corporation is the first step, often leading to a foreign national. And in fact, when we look at my own home district, it's not a small company. We all know the name Qualcomm, but Qualcomm is globally behind Huawei. And Huawei has the full backing of the Chinese government. And yes, they have a patent portfolio that couldn't be put in this room. There are so many. They are among the top 10 patenters of this year. So what happens? They're filing lawsuits. Well, that's fine if it says Huawei. But what happens when, in fact, they're backing them or through third parties backing them? That is happening every day. So, yes, I appreciate the fact that some conservative groups want to have this dark money and use it perhaps. I don't know why, but they might. We have put in the protections, and you will hear it and see it if you read the bill. We have put in the protections to make sure that, in fact, no innocent third party, no small donor, no one that can be intimidated is, in fact, subject to public display. Ultimately, the greatest protection is one that is in this bill, which is not a small difference, which is the in-camera review before and often to the exclusion of any further disclosure. In this case, if we don't trust federal judges to look at something, and we want to have a situation in which most of them don't, or if one of them doesn't, they can say, I didn't know, when in fact they allow these cases to go in large numbers through their court. Because I will tell you, the judges who ask for it are the judges being avoided by these black money users. So I am for the little guy, but let's not ever again be willing to say that the only little guy is the plaintiff. The little guy, disproportionately, when the trolls are going after, is one after another little guy. Yes, it does. We do see the large cases. I, too, was in litigation as a small company with Chrysler Corporation. And I've seen what it's like to go up against somebody who can hire a Pillsbury Madison and swamp you to where you can't even produce product for weeks. I also know that, in fact, the little guy can be on both sides. I've been that little guy. And with that, I think the ranking member wanted to strike the last word.
Thank you, but before I do, I would like to introduce a few things for the record by unanimous consent. One is Gene Hamilton for America First Legal.
Without objection.
Ex post opposing the bill. Second is a letter from the Investors Defense Alliance.
Without objection, so ordered.
Third is a letter from the Alliance Defending Freedom, strongly opposing the bill.
Without objection,
And
so ordered.
finally, an article from the Daily Signal Judiciary Committee debates bill against lawsuit investors.
Without objection, they will all be placed in the record.
If I could move to strike the last word, Mr.
The
Chairman.
gentleman is recognized for 5 minutes.
Thank you kindly, and I appreciate your point at the end about Chrysler. It does impress me that we're getting lots of very specific examples of little guys going against large corporations, and then we have some kind of hypothetical hearsay suggestions that, oh, it's actually little guys who are the ones who are being targeted. Look, this is the giant corporation bill of the year. Let's not make any mistake about what's going on here. And if you want to support it, you can support it. But this is big business's #1 bill, okay? And the whole theory is they are going to find out exactly, for the first time, as I can tell in American history, through the passage of federal law, exactly what are the resources that plaintiffs may have available to them if they're bringing a toxic tort suit or a suit against vaccine makers or a suit against environmental corporate defendants who've polluted neighborhoods or communities. They're going to find out exactly who you've got on your side. And they're going to be able to nail that down in advance. Now, what's the justification for this extraordinary intervention in the litigation process when judges can already ask for information if it's remotely relevant to the actual proceedings in the case? The justification is this all has to do with national security and foreign policy. And yet I don't see the State Department here today. I don't see the National Security Council here today. I don't think this information is turned over to the State Department or to the National Security Council. No, it's turned over to, guess who? The corporate defendant. If the judge needed it for a valid reason, the judge could already get it. It's the corporate defendant, the large corporate defendant, who wants this information in order to further stack the deck in terms of the ability of the plaintiffs to get a fair hearing in court, which is why I'm so glad to hear populists from left to right standing up for the little guys, from Washington State to California to Georgia to Vermont to North Carolina to Kentucky to Texas, people saying, wait a second, why in the world would we want to give this huge corporate giveaway to the biggest businesses in America? It simply makes no sense. Tomorrow we've got a hearing going on, by the way, about artificial stone slab workers who are dying because the big guys are prioritizing their profits over the safety of the workers. A great example of what's going on. And all we can think to do to enhance justice in America is to give information about how the plaintiffs are remarkably able to get into court to the corporate defendants in this case. So I'm going to be voting very strongly against this legislation. I'm curious to hear what narrowing amendments might exist, taking on good faith the proposition that this is really all about foreign policy and national security. Look, if we don't want China or Russia or an autocratic regime funding something in America, well then take that on directly and say, let's go ahead and ban that, right? But we don't need legislation that is going to, in a vastly overbroad way, intervene on the sides of the big defendants in these cases. And I haven't even thought about what it would mean to actually ban money coming from this or that source. After all, look, the way that we try to think about what goes on in court is that the court is ruling on the merits of the cause of action. And it doesn't make any difference how you got into court, whether you begged or borrowed the money to get into court to do it. The point is that the judge is going to decide questions of law. The jury is going to decide questions of fact. And so we're going to have integrity in that process, regardless of where the money came from. If we want to depart from that principle, let's look for a truly compelling reason to do it. But nothing remotely compelling has been offered at this point. On the contrary, it's a clearly political move by just some of the most powerful forces in the country. I yield back to you, Mr. Chairman.
Gentleman yields back. Gentleman, the gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I rise in strong opposition to this legislation. The gentleman from California offered for unanimous consent a letter from the trade group representing insurance companies. Yeah, they support this legislation, along with the multinational corporations, the crypto industry. They support this legislation. The data center folks, the AI folks who are looking to take your jobs, they support this legislation. This is a David versus Goliath situation. A left versus right is what we normally wrestle with here, but I agree with Representative Massey. It's not a left versus right thing. It's a big guy versus little guy thing. It's the underdog versus the strong opponent. It's the bully versus the 90-pound guy at the beach. It's the predator versus the victim. That's what this legislation is. It should not be titled the Protecting Third-Party Litigation Funding from Abuse Act. I'm sure that there is a more accurate title for it, such as the Insurance Company Relief Act. After we gave the insurance companies and all of these multinational corporations a multi-billion-dollar tax cut in the big ugly bill, while pulling funding for Medicaid and Medicare and Obamacare tax subsidies from the bill. You want to give them something else now. You want to pretty much give them immunity from being held liable to regular working people for harms that are done to them by these insurance companies that would take their premiums but refuse to pay for the claims, for polluters, for fraudsters who would take your money under false pretenses, for people who produce and manufacture unsafe products like medicine, like food, like baby furniture or clothing, corporations that do harm to people, you want to protect them by giving them immunity from lawsuits. That's what you're pretty much doing by making it unaffordable for the public to be able to sue these corporate wrongdoers. Suing in court is expensive, and corporations can defend all day and all night. They can defend the case till the cows come home, particularly when they know how much money you have available to fight them. They have unlimited resources to fight you, and they getting it, and they fight you based on getting a tax deduction for their expenditures, paying these white shoe, silk stocking, tassel shoe wearing, golden briefcase carrying corporate lawyers, charging $1,000 plus an hour, and they get a tax credit for that, a tax cut. They get a tax deduction for paying these folks who they hobnob with, by the way, at the country club. All of them together, the corporate lawyers, the insurance companies, the multinational corporations, having a party. They will also be meeting at Trump's addition to the White House, the gilded facility that he's deconstructed the White House to build. And these are the same folks standing behind him at the inauguration. Those are the folks that this bill protects, not the regular working people, the ordinary human beings in this country who work hard, play by the rules, and the only thing they want is to see their children rise up and do better than they, and that American dream has been lost, now can't even afford to buy a house or go on vacation. This bill is not addressing that issue. This bill puts more of your money into the pockets of these corporate wrongdoers. And for that reason, I oppose the bill, and I yield back.
Gentleman yields back. I believe the gentleman from Kentucky has an amendment.
Have an amendment at the desk.
Clerk will report.
Amendment to the amendment.
Reserve the point of order.
Point of order reserved by the ranking member from Maryland. Without objection, the amendment be considered as read. The gentleman from Kentucky is recognized to explain his amendment.
This is a very simple amendment. It's been proposed today by the proponents of the bill that this is about keeping foreign influence out of our courts and our foreign adversaries, keeping them out of our IP, and generally protecting America from foreign influence. So my amendment, offered in good faith, would limit this bill to exactly that. It says, and it makes an exception for the financial disclosure for anybody who's a citizen or lawful permanent resident of the United States or any entity organized and principally operated under the laws of the United States or any state thereof, and not controlled directly or indirectly by a foreign person. That's all the amendment does. It's very simple. It basically says that this bill is about foreign adversaries, and we're not going to make it broadly applicable to other things. And I yield back.
Gentleman yields back. Gentleman insists on his point of order.
No, I just want to speak in favor of the amendment.
Gentleman is recognized.
Thank you, Mr. Chairman. The amendment is one that I think everybody should be able to agree to, because it answers what we take to be the major point of the proponents here, which is that this is an effort to isolate and repel foreign influence. And so the gentleman from Kentucky's amendment carves out from the bill people who are natural citizens of the United States, as well as entities organized and operating under the laws of the United States and not controlled by a foreign person. So I think this vindicates the purpose of what the legislation is, and at the very least we could then debate meaningfully the suggestion that it's a danger to have the litigation that's being financed by, someone who is either directly or indirectly being influenced by a foreign entity. So I appreciate his clarification of the legislation. I would assume that everybody in good faith would adopt it, and then we can go forward to try to analyze the legislation. Thank you, and I yield back.
The gentleman from California is recognized.
Thank you, Mr. Chairman. He's moved to strike the last word.
Gentleman's recognized.
Mr. Chairman, nowhere in this legislation did we say this was a foreign entity nefarious prevention act. The fact that, yes, Huawei, with its hundreds or thousands of tentacles in the U.S., including U.S. entities that would gladly funnel money into third-party litigation, could in fact be involved. And I think in the case of trying to thwart 5G, which they've done a pretty good job of, in fact, participates. But they're not limited. My example included the George Soros article. That George Soros article is from 2018. This is a growing problem. It has been for a long time. And last time I checked, George Soros is an American citizen. What is important to understand is, what if the litigant, the true litigant, is your rival, your competitive rival, who only wants to, in a patent litigation, see your intellectual property, get behind the disclosure so they can find out what your sales are, what your profits are, what your margins are, how many units you sold. Now, I don't know how many of you have been defendants or plaintiffs in a patent case, but I run out of fingers and toes before I get done with all of my cases. And I can tell you, when I'm a defendant, the most important thing they want to know is how many I sold. And when they know that, they know what they need to know about market share, one of the most important parts of their consideration. They don't have to win the case, they just have to win the discovery. So the fact is that by exempting all American entities, including green card holders, American corporations, shell corporations, and so on, from discovery by the judge, from in-camera review by the judge, you don't just gut this legislation, you gut the very concept that there's a reason you're supposed to know who your accuser is. In a criminal case, it's undoubtable. But in a civil case, it is still expected. It simply isn't happening. Your true accuser could, in fact, be your arch rival in business, but you don't know that. The true recipient of that very confidential, in some cases, information that isn't in patents, but is, in fact, a trade secret, becomes discoverable. And for a little company, that emerging company, trade secrets can be everything. So the fact is, I oppose this, and I think all those who support underlying reform will certainly see this as of no value in improving the bill. And Mr. Chairman, I yield back.
Gentleman yields back. Gentleman from Georgia is recognized.
I rise, Mr. Chairman, to strike the last word.
Gentleman's recognized.
I rise in support of the amendment. I'll point out that in a David and Goliath world, David is the winner in the minds of the people. This is a David and Goliath bill. The bill protects Goliath from David. And it actually makes no sense because David is already weak and has a limited arsenal at his disposal, just a small rock, whereas the big giant has the weight of the Supreme Court, the weight of its money, the weight of the legislative branch, the weight of the executive branch. It's got everything going for it, but it wants more. Like a fat person, just a glutton, just can't stop stuffing their face with food. In this case, it's money. The more money I get, the fatter I get, the more the more I want. It's just, it's ridiculous that when the American people are the ones who need our assistance, we need to level the playing field for them, but we want to tilt even further the playing field in favor of these giant Goliath corporations. It's not fair, it's not right. The American people realize what we're doing here, not a thing to help lower their costs, not a thing to help bring fairness to an unfair environment. No matter how hard you work, it seems like you just can't. It all goes to nothing. You work hard, your kids are suffering, your wife, everybody. And here we have Congress doing everything it can to make it even more comfortable for the rich, the wealthy, the well-connected. The fat cats are getting fatter. It's just, I mean, what we're doing, the American people see through it. This legislation would even cause problems for Epstein file victims to be able to sue corporate defendants who are alleged to be complicit in their victimization. I don't know if the gentleman from Kentucky would want to add to that.
Would the gentleman yield?
I would.
Yeah, I think it encompasses, it started out as an IP bill, and then I think to hide the nature of it being an IP bill, it was broadened in hopes of broadening the constituency of corporations who would be interested in this bill. But what has happened is it has also broadened, I think, the constituency of people who should oppose this bill. The Davids, not the Goliaths, which could include people who've been harmed, for instance, by pesticides, or people who've been sexually abused or trafficked. And if I may take a few more seconds to talk about the bill's sponsor, his opposition to my amendment, he said that it's not fair that the defendant has to disclose the number of products sold or things like that. Well, that is material to the lawsuit. What is not material to the lawsuit is how you borrowed your way into court in order to hire that lawyer to get there. That is not material to the case. And so that would be my rebuttal to, it's not fair that the big corporation has to say how many times they stole the patent in order to determine the outcome of that trial. And I yield back to, that was Mr. Raskin's point that I'm reiterating, but I yield back to
Thank
Mr.
you.
Johnson.
Will the
I'll
gentleman
yield to
yield?
the gentleman from Florida.
I was listening to your passionate testimony. I wanted to hear a little bit more about the fat cats, if I could. Just a little more elaboration about the tassels and the briefcases. Like how gigantic are these fat cats?
These are real big folks. They're huge, as a matter of fact. Huge.
Would the gentleman yield?
Yes, I would.
So at what weight can I get this bill through? You know, at 160 pounds, 140 pounds. I do have a question for the gentleman, though. If the defendant is a small business, do they get to use this? You know, you've mentioned large businesses, but how do you feel if it's a qualified small business against a large one? Should they be able to use this bill?
I think the playing field is as level as it can be at this particular time, though it's not level enough. And this legislation will tilt it even more in an unbalanced direction. So that's why I oppose this
Time of the gentleman
legislation.
expired. The gentleman from California is recognized.
Thank you, Mr. Chair.
Wait, excuse me, I'm sorry, Kevin.
Oh.
I got to go in the order, I need to go in order. The gentleman from Wisconsin, then we'll come to the gentleman from California.
Yeah, Mr. Chairman, just a quick comment. I mean, to me, the reason I was attracted to the bill or thought the bill made good sense is because the legal system is being skewed, that the system is being leveraged by outside dollars. It's that simple. There's money coming in from the outside that quite honestly, I'm not sure how you can justify that. And eventually, the $18 billion that's being used to skew the system makes no sense. And I think the amendment makes the case. Because what you're saying is, yes, let's get these foreign governments out of this particular discussion. Let's make sure that we somehow carve that piece out and say, yes, that's justified. You know, I get it. It's part of the security piece. But you're admitting basically that the system is skewed. That right now we've got outside dollars coming in that no one knows where it's coming in. And in some instances, it's already been proven it's there to leverage and sometimes to gain damages. So, I mean, maybe this amendment narrows it, but it also makes the case, I think, that the system's broke. It's broke right now. And if that number of 18 billion continues to escalate, we'll just be back here in the next Congress doing it again. Because it's not working the way it's set up right now. It's just not working. And you can talk about the little guy, but, you know, at the end of the day, the client is not in control of their own cases anymore. Yep. They're just not. They're not in control of it. Somebody's out there shopping for outside dollars to fund these. And that's why I think we're just going to be back here next Congress doing the same thing.
Will the gentleman yield for a question?
Sure.
So I appreciate your bringing our attention to what are the systemic effects of this. But when you say it skews the system, I wonder if you could be more specific about that. I mean, say my community is a victim of some kind of environmental harm, and we decide to go to court to try to vindicate our rights and to sue to stop the harm. Tell me how our getting third-party funding from any particular source will alter the course of the litigation or the integrity of the proceedings when the court has to make sure it's deciding on the facts, on the evidence, and based on the law.
Well, I don't know how TPLF kind of makes a difference necessarily in that scenario, other than the relationship between, you know, the person that's engaged in a lawsuit, and suddenly they're making decisions about where they should go with that lawsuit based on dollars that clearly are leveraged, so that when the case is settled, there's going to be a windfall.
Would the gentleman yield?
That's what's going on right now.
Would the gentleman
That's
yield?
what's going on. Yes.
Yes. I might further your comments by answering that the reality is you need to know who you're settling with. You need to know who you're negotiating with. The very disclosure that there is a third-party entity who has any operational control or benefit should be discoverable, but currently often isn't. So you might be talking to someone, you might be in litigation with somebody, but you don't know. And as I'm sure the professor knows, the fact is that mandatory arbitration and mediation and conferences often go on time and time again, and they are simply a waste of money if the people who show up are in no position to do anything other than burn your money. So there are many reasons for it, but I will comment, if I don't mind, on the idea that one is discoverable and one isn't. The depth of a pocket for defense when it's insured is in fact always discovered. The depth of the ability to pay is always discovered. That sounds great, except you haven't been convicted of anything. It happens at the front end of it, and at that point you have no idea. We're not talking about how deep the pockets are. We're talking about who the pockets are. And I appreciate the gentleman yielding.
Yield back.
Gentleman from Washington.
Thank you. I'd like to speak in support of Mr. Massey's amendment because I think that this is one of those situations where we've got people on both sides who are concerned about the enormous amount of money and leverage that these giant corporations have in these lawsuits and the amount of power that this legislation as originally drafted would give to those entities. And I'm confused, frankly, by the changing nature of even what this legislation is supposed to accomplish. Because originally I thought it was supposed to be about these foreign funders who were, and I think Mr. Massey's amendment narrows it substantially to say, all right, if that's the problem we're supposed to be addressing, then let's address that problem. But now it seems that we're coming back to a whole set of other arguments about the legal system being skewed. If it's skewed in favor of those giant corporations. There are so many little guys who never get a shot at even getting to court. They don't have the money to get to court. There's no way they can even think about it. And so if you were to analyze the amount of money in the system right now, it's skewed towards the big guys. And I think the concern and the reason that there is both support from both parties on this against the original piece of legislation is because we have similar views that right now the system is being utilized, supported, funded by those giant corporations. This bill in its original form would just give more tools to those big guys. And Mr. Issa, I'm sorry, I don't know that there's going to be any weight at which the fat cats are going to get lean enough that we would want to support this because they're really huge right now. And I think that this amendment from Mr. Massey is actually a sensible way to narrow the bill and to really try and get at what is it supposed to be about. Because in each hearing, it seems to change a little bit. So I'm very supportive of this amendment, and I hope we can pass it.
Would the gentlelady yield?
Yeah, I would.
I would ask you to, notwithstanding today, come to our hearing tomorrow. We'll wave you on to the subcommittee. And you can see, in fact, one after another small companies finding themselves swamped in claims for a product that they never touched, they never bought, they never manufactured, and in fact, they didn't control even who ultimately bought the product. They have no idea until they're sued. So we do have examples, and they are small businesses. They're actually in Congressman Guerrero's in his district. So we see them every day.
I appreciate the offer. I would say that for every one of those examples, I guarantee you that the vast majority of examples that we find are not those examples. And listen, this happens where somebody will find a small business. I'm not saying that's never the case. I'm sure that's the case. But the vast majority of money right now is coming from the giant corporations, and the vast majority of people who would be benefited by the bill are the big guys. And I think we need to be looking at legislation in terms of what the effect is going to be on the entire system that already discourages the little guy from even getting into court. I mean, that's a very difficult thing to even get into court and have the money. Looks like the ranking member would like, he's looking so thoughtful.
I've got a question for you, if that's all right, if you'd yield.
Yeah.
What's odd about this legislation is that the rhetoric goes a lot further than the actual measure. So if you take what our friends are saying seriously, like the gentleman from Wisconsin, there's something illegitimate about having third-party funding at all. Well, then why not just try and ban it? Mm-hmm. Why not prohibit it if there's something wrong with it? But if there's not something wrong with it, if I've got a right to take out a loan from whomever I want or to get money from whatever source I want to, if that's a right as a U.S. citizen to do it, to go to court, then leave us alone and stop harassing us, because that's what it is. It's basically big business harassment of little people trying to get into the legal system.
I completely agree with the ranking member, and I think that we're getting at some of the crux of the problem in the system as it stands today. I yield back.
Yield back. The gentleman from California is recognized.
Thank you, Mr. Chair. I think there's definitely truth on both sides of the argument here. I'm not sure I fully buy the image of David versus Goliath on one side or the fat cats on the other side. I think it is true that this bill would crack down on abuses. Well, it's also true that it would likely deter or chill meritorious litigation. I think it's true that the bill could level the playing field when it comes to disclosure, while also potentially further unleveling the playing field when it comes to resources. So just listening to the debate, it's pretty clear to me that this will not have the votes to pass on the floor, let alone get to 60 in the Senate. So if we actually want to make policy here, and this is a complicated policy, there's all kinds of exceptions and exceptions to the exceptions and so forth, why not narrow it to that class of cases that we can all agree are the most concerning, those where you have foreign influence involved, and see how the policy plays out there, and then we could revisit it in the future. I'd be happy to yield to Mr. Issa, Mr. Peter, or anyone else.
Well, the amendment as it is, doesn't say how you discover that. Are you in considering that this amendment by Mr. Massey should be changed to allow for in-depth discovery? Because if I can't know that the third-party funder is, in fact, when I go up the chain, the Chinese Communist government, I'm not going to find out by simply the U.S. company saying, I'm a U.S. person, and that ends it. So even if we were to go with narrowing it the way Mr. Massey is saying, all cases would have to essentially come to the judge in camera to try to figure out, does it have that element? And then the question is, how would you do further discovery? Many of the things, and I want to thank you and take you at your word that perhaps there is a narrowing, but perhaps the narrowing is that if the defendant has sales less than $100 million or a net worth of less than $10 million, they would be entitled to this information, because at that point, they'd be pretty slim. But it sounds like the people on the other side don't think that I'm thin enough or that I'll ever be thin enough. And I'm, quite frankly, pretty happy where I am. I don't think I want to get any thinner. The reality is that this did start off concerned about intellectual property. And if I could write the bill in the narrowest way, I would say it only concerns patent and intellectual property related cases. But to be honest, Mr. Massey objects to that and doesn't really give a darn about the rest of it by comparison. So it isn't going to change the fact that we have narrowed this to an in-camera review by a federal judge, and it need go no further if the judge sees no need for it to be disclosed further. And quite frankly, I don't know how you narrow any more than simply saying we trust a nonpartisan lifetime appointment judge to simply look and say, is there a reason particularly to affect the protective orders as to who gets information when there is a third-party profit and loss participant who might even be a competitor? Thank you, gentlemen.
I yield to the gentleman from Kentucky.
I think the gentleman from California, if Mr. Issa wants to narrow my amendment, I'm open to language to do that. I think it's sort of problematic. You might let the cat out of the bag in the very beginning when you try to, if you put very specific things in there of how you're going to find out if there's foreign interest or not. But I'm sure there's a way to do it. And I'm sure there's a way to limit the in-camera review. I have another amendment to your bill because I've got some concerns about the in-camera review. We may or may not get to that today, but if you have any ideas, I'm open to how we make sure that the bill is limited only to foreign entities.
Thomas, if I can ask you, if we did that, would you vote for this bill?
I would consider it. I would.
In other words, you're not saying you'd vote for the bill.
Well, I want to see what your fix is to do that.
If this amendment were passed, would you vote for the bill?
I would consider it.
I rest my case. I thank the gentleman for yielding.
I yield back.
Gentleman yields back. The gentlelady from California.
Thank you, Mr. Chair. I would be supporting this amendment because I agree with some of the discussion that I've heard. This is a very serious issue that actually warrants a longer discussion because this is a problem that we all face within this legal system. I mean, at the end of the day, I hope what everyone wants is that regardless of who you are, if you are harmed, you should be able to go to court, plead your case, the merits of the case should be listened to, and you should be able to prevail if the merits stand. And it shouldn't be about how much money you have. And I just don't understand why our colleagues are so upset that plaintiffs are now kind of doing what they need to do to figure out how to get the financing they need to at least give them a shot at justice in the courtroom. At the end of the day, it is about leveling the playing field so that the little guy does have a chance. Now, we keep talking about foreign money and foreign influence, and, you know, I mean, we should also have a deeper conversation about that, because there's actually a lot of foreign dollars that are already tilting the scales to the side of these big corporations, because there are sovereign wealth funds, there are foreign investments and investors that are putting their money in these big corporations. And that's how they're able to beef up their infrastructure. That's how they're able to beef up their legal arsenal. That's how they're able to continue to snuff out the little guys. So the foreign money, I don't know about the black money, but the foreign money is already making its way through this system. Trust me. The big companies are like, how do I get bigger? Okay, monopoly time. Okay, how can I do this? Okay, foreign investments. Okay, they're trying to get a profit. Okay, they're going to get bigger and turn into a Pac-Man. Okay, little person, you're screwed. So why don't we jump way down the rabbit hole and unpack all of it, so that we can try to do what many folks say, but not many folks do, which is stand up for the little person, so that they feel like the courtroom is as open to them as it is to the person walking in with the silk stockings and the tassels and the gold briefcase and all that. Because I don't know, when you are hurt because you're making some quartz countertop for some rich guy who's buying their 5th home, when you are hurt because you're not getting the disclosures you need and you're taking some medicine that's hurting you, and the hospital or the doctor's not trying to help you, when you are hurt when you go into the store and something bad happens and they just throw you out and try to like weigh you down with all of their lawyers so that you walk away, that's not helping David. That's not helping the little guy. That's not helping most of the constituents that we represent that live in our district. So I do support this amendment, and I think we should actually have a deeper conversation about third-party financing, and I think we should also have a conversation about foreign influence and foreign dollars that are already in the system, making these big corporations even bigger. Even bigger. And with that, yes, I would like to yield to the ranking member.
Thank you very kindly. I just wanted to add to the gentlelady's comments a point in response to the distinguished gentleman from California, Mr. Kiley, who makes the eminently reasonable suggestion, given the intense controversy this bill has created, why not go with the narrowest basis for the bill, the one that was originally promoted to everybody as the basis for it, which was to repel foreign influence. And the answer that we got from the gentleman from California is, well, it would be too inscrutable and indeterminate to figure out who actually was a natural person, who actually is an entity organized by the United States. But in fact, if you look at the grammar of the amendment offered by the gentleman from Kentucky, all of this comes within the discretion of the party, which has the new obligation to disclose in writing to the court all other named parties of the civil action that has a legal right to receive any payment. So they would be the ones to say, except where it's a natural person. That's not complicated at all. That makes it very simple. Thank you, and I yield back.
Gentlelady yields back. Question, we got a
Move to strike the last word.
gentleman from New York's recognized.
I will not take my full 5 minutes, but the pretty clear divide that I think we're trying to get at here is a debate between making sure we have access to courts, making sure that there is an ability to redress situations, which requires some evening out of the system so that large corporations cannot bludgeon plaintiffs to death with discovery, with motions, et cetera. On the flip side, I do understand Mr. Issa's concern that if we are dealing with trade secrets, intellectual property, and you have an unidentified foreign investor, potentially a competitor, potentially someone who can use those trade secrets with something else, that's a concern. But this doesn't address the direct balance here in a meaningful way. And I could be wrong, but I think that's what Mr. Kiley was trying to get at here, is that there is a way of enabling plaintiffs to get access to court and to be able to adjudicate their claims with third-party support, to put up some of that money that is necessary to combat the massive amounts of money from the defendants. That's an important thing. That's very important in terms of just access to courts. If you have a third-party litigator, and separate and apart from the discovery aspect of it, you are ultimately going before a judge who is going to make the decision as to whether or not there's a legitimate claim. Now, Mr. Issa is concerned about small businesses getting pummeled with, with lawsuits that they can't afford. They have to do a nuisance settlement that they can't afford. Legitimate concern, but this is not the way to solve that. We can do serious tort reform so that there are more serious penalties for frivolous lawsuits or for overreaching.
Will the gentleman yield?
Yes, of course.
Well, and I wonder, given your experience, whether you would agree also that lawyers have a professional responsibility to represent their clients and not some third party. And so there's a duty of honesty and candor before the court if somebody's actually representing somebody who's not a plaintiff in the case.
Well, of course, I think, yes, obviously the plaintiff is the plaintiff, and if somebody wants to invest in that claim, that is not the client. And I think what this ultimately goes to is that corporations don't like the fact that plaintiffs may level the playing field in terms of finances. I mean, that's just simply what the opposition to third-party litigation is that corporations, large defendants, feel like they have the upper hand, and they don't want to give that up. I agree with my colleague from Washington that for every small business that has to deal with the multiple nuisance suits, I'm sure there are exponentially more small plaintiffs who get run out of court. But this just, I know we worked on this and we postponed it, but there is something here that we can agree on, but it has to include access to courts in a meaningful way while protecting our national security. And that's why I do support the amendment, but by ultimately the way that this is written makes it impossible to do that. And I'll yield to Mr. Massey.
I don't think there's anything wrong at all with the wording of my amendment. If it's flawed, then so is the entire bill. Because the bill relies on the lawyers being honest to the judge. And I believe what Mr. Issa implied was, what do you do if the lawyers are lying to the judge about foreign influence? Well, the whole bill has that defect. They could lie to the judge about anything. So, and I don't think it's a defect, by the way. And I think the amendment is just fine as it's written. And I yield back, Mr. Golden.
Thank you. Yeah, that was, I was not directing my comments at you. I agree that as written, the amendment, which I support, would address the concern of U.S. citizens versus foreign entities or persons. And I yield back.
Gentleman yields back. We have 4 votes on the floor. The committee will recess for those 4 votes, and then, pardon? 8 votes on the floor, 4 bills, I guess 8 votes. 8 votes on the floor. The committee will recess and resume when the vote series is over.